Hi, it's me again, your criminology review partner, and today we will be discussing about preliminary titles and felonies on our revised Penal Code Book 1. Before everything else, please click the subscribe button and hit the notification bell to be notified on the next video. So now, let us start discussing with Article 1 and its provisions. This code shall take effect on January 1st, 1932. RPC took effect on January 1st, 1932, but was passed into law on December 8th, 1930. Article 1 is just about the time when our revised penal code took effect, so just remember thee and take notes of the dates. Now, let's proceed with Article 2. Get ready with your notebook and remember these examples. The first paragraph provides for the intraterritorial application of the RPC. The RPC shall be enforced within the Philippine archipelago, including its atmosphere, its interior waters and maritime zone. Exception, as provided in treaties and laws of preferential application. This phrase means that treaties entered into with other countries, laws of preferential application takes preference over the provisions of the RPC. Whenever the Philippines enters into a treaty with another country and the stipulations in the treaty is not in consonance with the RPC, then the provisions in the said treaty shall prevail over the RPC. The second paragraph provides for the extraterritorial application of the RPC. These are instances wherein the RPC can be applied, even if the crimes are committed outside Philippine archipelago. 1. Should commit an offense while on a Philippine ship or airship. A ship or an airship is considered a Philippine ship or airship when it is registered in the Philippines under Philippine laws, even if it is totally owned by a Filipino citizen. If it is not registered in the Philippines, it cannot be considered a Philippine ship or airship. Now, the law says, when a crime is committed on board a Philippine ship or airship, the extraterritorial application of the RPC will apply. It means even if the crime is committed in another place outside the PH jurisdiction, still, the RPC will apply. So what is this situation? This is a situation where a crime is committed on board a Philippine vessel PV while it is outside the PH territory, but not in the territory of a foreign country. The PV is on waters of the Philippines and a crime was committed on board. It is necessary that the Philippine ship or airship is outside the PH territory, but not inside the territory of another country. If the PV is in territory of another country, then Philippines will have no jurisdiction. The law of that country shall prevail.
The Philippine vessel was on Philippine waters. While the vessel is in the PH waters, a crime was committed on board the vessel. What country has jurisdiction over the said crime?
Thank you for that question. The answer will be the Philippines. The vessel is in Philippine waters. Article 2 first paragraph, intraterritorial application will govern.
Last question, please. What if the PV is on the high seas or international waters not owned by any country and a crime was committed on board? What country will have jurisdiction?
Still the Philippines because of the extraterritorial application of Article 2 second paragraph. The PV is outside the Philippine archipelago when the crime was committed, but it is not in the territory of another country. Hence, the RPC should still apply.
But I still don't understand. What if the PV is on the waters of Malaysia and the crime was committed on board? What country will have jurisdiction?
Malaysian courts will have jurisdiction because of the territoriality characteristics of criminal law. As a rule, penal laws are territorial in nature. But there is exemptions. If the vessel is a Philippine warship or warplane, wherever it may be located, it is always the Philippines that will have jurisdiction, because a Philippine warship or warplane is considered an extension of the Philippine territory. 2. Should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands. 3. Should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. The following two circumstances, if the forging and counterfeiting were done in a foreign country, the offender can be prosecuted before the PH courts. Philippine laws will apply because of the extraterritorial application of the RPC under the second and third paragraph. X was arrested in Japan because he was caught in the act of counterfeiting the Philippine peso bill, likewise Philippine securities issued by the BSB. Can he be prosecuted before Philippine courts? Does Philippine law apply? Yes. Although the crime has been committed in Japan, he can be held liable before Philippine courts. 4. While being public officers or employees, should commit an offense in the exercise of their functions. This refers to public officers and employees of PH government who are working in another country, even if they are assigned in a foreign territory, since they are public officers of the government, if in the said country they commit a crime in the performance of their official functions. They can be prosecuted before Philippine court. But if the crime committed is not in any way connected with the exercise of their functions, they should be prosecuted in the courts where they are assigned, because although they are public officers or employees of the Philippine government, they acted in their private capacity. And lastly, 5. Should commit any of the crimes against national security and the law of nations, defined in Title 1 of Book 2 of this code. For those who are not familiar, kindly check the other video on introduction. Next will be a brief discussions on Article 3, Felonies. Acts and omissions punishable by law are felonies delitos. Felonies are committed not only by means of deceit dolo, but also by means of faute culpa. 1. There is deceit when the act is performed with deliberate intent. And 2. There is fault when the wrongful act results from 2. 1. Imprudence. 2. Negligence. 2. 3. Lack of foresight. Or 2. 4. Lack of skill. 2 kinds of felonies. 1. Intentional felony, those committed with deliberate intent. Element CIFI 1. Criminal intent on the part of the offender. 2. Freedom of action in doing the act on the part of the offender. 3. Intelligence of the offender. Is an intentional felony a voluntary act? An intentional felony is a voluntary act because it is committed by means of deliberate intent. The offender knowingly, willfully and voluntarily committed the act. The next kind of felony is 2. Culpable felony, when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Element CNFI 1. Criminal negligence on the part of the offender. 2. Freedom of action in doing the act. 3. Intelligence on the part of the offender. Is a culpable felony a voluntary act? Yes, it is also a voluntary act, although it is committed with negligence, not with deliberate intent. Note: both intentional and culpable felonies are voluntary act. Without voluntariness, there can neither be an intentional or culpable felony. Can a crime be committed without criminal intent? Yes, a crime can be committed even in the absence of criminal intent. 1. In case of crimes brought about by imprudence, negligence, lack of foresight, or lack of skill, otherwise known as culpable felony. 2. In case of crimes which are violation of penal laws. Next we'll be discussing the difference between acts mala insi and mala probita. Acts mala probita acts which are only wrong because there is law that defines and punishes the said act. Without the said law, said act will not be considered a crime. In simple terms, it is an act made evil by the law or crime by statute. Example: possession of firearm. Mere possession is not criminal in nature, but possession of firearms without license and without permit to carry is considered criminal and illegal because there is a law. Next is crime mala insi. These are acts which are inherently evil or wrong by their very nature. It is wrong per se. Even if there's no law, it is evil. So basically, these are acts which are evil in itself. Examples: 1. Killing a person. 2. Molesting a woman. 3. Taking the thing of another without the consent of the owner. There need not be a law to say that these acts are wrong. They are by nature wrong. Next, let us proceed to Article 4, Criminal Liability. Criminal liability shall be incurred: 1. By any person committing a felony delito, although the wrongful act done be different from that which he intended. Proximate cause doctrine. 2. By any person performing an act which would be an offence against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. This article involves a lot of different topics that needs to be discussed separately, so we will move on to the next article, and we'll just make a separate video in art. 4. For clear discussions and examples. Let us move on to the next article. Article 5. Duty of the courts. Duty of the court in connection with acts which should be repressed, but which are not covered by the law, and in cases of excessive penalties. Whenever a court has knowledge of any act which it may deem proper to repress and which is not punishable by law, it shall render the proper decision, and shall report to the chief executive, through the Department of Justice. The reasons which induce the court to believe that said act should be made the subject of legislation. Next article will be Article 6, Stages on the Commission of the Crime. 2 phases in the commission of the crime. 1. Subjective phase portion of the commission of the act, wherein the offender commences the commission of the crime after the time that he has still control over his acts. He may or may not proceed in the commission of the crime. He still has control over his acts. 2. Objective phase offender has no more control over his acts. He has already performed all the acts of execution in the commission of the felony. Note, if the subjective and objective phases are present, there is consummated felony. 3 stages in the commission of felony. 1. Attempted when the offender commences the commission of a felony directly or over acts, and does not perform all the acts of execution which should produce the felony by reason of some cause or accident, other than this own spontaneous desistance. 2. Frustrated when the offender performs all the acts of execution which would produce the felony as a consequence, but which, nevertheless, do not produce it by reason of causes independent of the will of the perpetrator. Lastly, 3. Consummated when all the elements necessary for its execution and accomplishment are present. Before we proceed to the next article, let us digest this simple scenario. Juan said Pedro. Pedro died. Consummated. Juan said Pedro. He regret what he did because Pedro is his friend after all. He brought Pedro to the hospital, frustrated. Juan is on the act of stabbing Pedro. Pedro noticed Juan and evaded his attacks and run, attempted. That's the main difference of the 3 stages. Our next article is Article 7. Under Article 7 of the Revised Penal Code, we have, as a rule, light felonies can only be penalized in their consummated stage. Exception to the rule, light felonies against persons, light felonies against property, even in the attempted or frustrated stages. The offender incurs criminal liability. Our Article 8 is all about conspiracy and proposal to commit felony. It states that a conspiracy exists when 2 or more persons come to an agreement concerning a commission of a felony and they decide to commit it. And there is proposal to commit felony when the offender who has decided to commit a felony proposes its execution to some other person. So as a rule, the conspiracy to commit a crime is not a punishable act because it is a mere preparatory act. Exception to the rule, as provided by Article 8 first paragraph. Conspiracy to commit a crime shall be punishable only when the law especially provides a penalty therefor. For example, are those conspiracy to commit treason which are punishable as defined by law. We're almost done, so let's hop on to the next article, Article 9. Classification of felonies according to severity. According to severity, felonies are classified into grave, less grave and light felonies. Grave felonies are those to which the law attaches the 1. Capital punishment or 2. Penalties which in any of their periods are afflictive, in accordance with Art. 25 of this code. Next is less grave felonies are those which the law punishes with penalties which in their maximum period are correctional, in accordance with the above-mentioned article. Lastly, light felonies are those infractions of law for the commission of which the penalty of 1. Arresto mena or 2. A fine not exceeding 200 pesos or 3. Both is provided. And with our last article to discuss today will be Article 10. Offences which are or in the future may be punishable under special laws are not subject to the provisions of this code. This code shall be supplementary to such laws, unless the latter should specially provide the contrary. That is all about our brief discussions on Article 1-10 of our revised Penal Code. Make sure you have already subscribed to the channel to be notified for the next video. This is once again your Criminology review partner. Until next time.